In a recent order, the Supreme Court has made significant observations which expand the traditional meaning of family. As we know, familial relationships are perceived to predominantly consist of mothers, fathers and children. However, that is not always the case. Pertinently, the Supreme Court has noted that familial relationships can also consist of atypical family units like domestic unmarried partnerships and queer relationships, and that they are also entitled to legal recognition and protection. A bench comprising Justices D.Y. Chandrachud and A.S. Bopanna made these observations while granting the relief of maternity leave to a central government employee, regardless of the fact that she had availed childcare leave for the children of her husband from his earlier marriage. This particular case challenged as to who classifies as caretakers or guardians of a child. The petitioner had been denied maternity leave for her biological child because she had earlier availed maternity leave before to take care of one of the children of her husband from a previous marriage. Her maternity leave was called into question on the ground that this wasn't a traditional family, addressing the assumption that the concept of a family both in law and in society is that it consists of a single unchanging unit with a mother and a father who remain constant over time and their children. The Supreme Court underscored in the order that this assumption ignores the many circumstances which may lead to a change in one's familial structure and the fact that many families do not conform to this expectation to begin with. The Supreme Court acknowledged that a household may also consist of a single parent household for a number of reasons, including the death of a spouse, separation or even divorce. Similarly, the guardians and caretakers who traditionally occupy the roles of the mother and father of children may change with time due to remarriage, adoption or even fostering. These manifestations of love and families may not be typical, but they are as real as their traditional counterparts, and notably they are equally deserving of not only the protection under the law but also of the benefits available under different social welfare legislations, the court emphasized in this very progressive ruling. The judgment further noted that the law must not be relied upon to disadvantage women who take on the role of motherhood in ways that may not find a place in popular imagination. These observations, although they are obiter, are significant, particularly in relation to queer relationships, as the LGBTQ community has been raising the issue of legal recognition for same-sex marriages, especially after the decriminalization of consensual homosexuality back in 2018. The judgment, with its observation that the law must not disadvantage women who take on the role of motherhood different from popular imagination, also opens the door for legal rights of women who avail surrogacy, adoption or even assisted reproductive technologies. Pertinently, multiple petitions are now pending before the Delhi High Court seeking to recognize same-sex marriages in India under the Special Marriage Act, Hindu Marriage Act and even the Foreign Marriage Act. The judgment, with its observation that the law must not disadvantage women who take on the role of motherhood in ways different from popular imagination, also opens the door for legal rights for women who avail surrogacy, adoption or even assisted reproductive technologies. Thank you. This is Aratrika Bhaumik reporting for LiveLaw. Please let us know what your views are on this very progressive ruling.